and the Honorable Court.
Please be seated. Welcome to the 14th Court of Appeals. Were y'all notified about the change in the panel? All right, because I'm not Justice Poisson, so if anybody wants to do a recusal or anything like that, and if not, we're good. All right. So we have one case on the docket, Pure Investment Group LLC and Eunice Dogan versus 1168-1 Interest Limited. Counsel, if you'd like to make announcements.
James Merrill on behalf of the appellants, I'm joined by Tom Smith.
Misty Howard, now on behalf of the appellee 11681 Interest LTD. I'm by myself today.
All right. Have you reserved any time for rebuttal?
Yes, Your Honor, I have reserved 3 minutes.
All right. Well, I think we're ready when you are.
May it please the court, my name is James Merrill. I represent the appellants, Pure Investment Group and Eunice Dogan. Mr. Dogan's responsibility and liability in this case is purely vicarious as the guarantor. So unless the court has questions specifically to Mr. Dogan, I'll be addressing most of my attention to the claims against Pure. A brief factual introduction. Welcome to the case, Justice Spain. This is a commercial landlord-tenant dispute. Pure Investment had a novel concept, and that was to open up a hybrid restaurant market.
A grocerant.
A grocerant, yes, Your Honor. It would be similar.
That was a new one.
I'm sorry?
That was a new one.
That was a new one, yes, Your Honor. I think maybe that's the new term. Eatzi's, if the court's familiar with Eatzi's, showed up for a little while in Houston, up in Dallas. It's similar, but not quite the same restaurant concept. The tenant specifically chose this location because of its proximity to the Royal Oaks community, which was prestigious, because of the ample parking and including the representations that there would be 700 parking spaces, and because of the ingress and egress for the community. The only evidence in this case is that Pure did make modest profits before it was forced to close down. Parking was a huge issue for Pure, as the testimony showed, because the city of Houston has its own parking ordinances that require that a restaurant like Harvest had to have a total of 120 parking spaces to comply with the parking ordinances. Here there were only 70 spaces, and so they had to make use of what was the common or shared parking spaces. Harvest closed in September.
I'm sorry, the 70, were they the 4 per 1,000? Was that the 4 parking spaces per 1,000 square feet? Does that equal 70 spaces?
No, no, Your Honor. We needed to have 120 because we needed to have 115 for the 10 parking spaces for the 11,500 square feet.
Got it.
It just turns out that the only parking spaces that were close to the restaurant were about 70 spaces.
Okay.
So we had to make use of the shared spaces.
Okay.
As it turns out, the customers used the parking spaces that were right behind the restaurant. Most of the customers did. Harvest closed in September of 2015, about a few months after construction started on a Trader Joe's restaurant that was put right on top of where the parking was that was used by the Harvest customers. The landlord sued us like they've sued every other tenant in this case, and our primary defense to the landlord's claim was that we were constructively evicted. It was our burden on constructive eviction, whether for our affirmative claim or defense, to be able to prove 4 elements, and I'm going to focus particularly on the intention by the landlord that we no longer enjoy the premises in the material act. The jury did not find constructive eviction. It's our contention the reason they didn't do so is because they didn't have critical evidence in front of them. And so for that reason, the judgment should have been reversed and remanded. We appreciate the opportunity to argue today. This case has a whole lot of arms and legs. Part of that's my fault, and I apologize. I would like to try and walk the court how I think this case should be resolved. That said, I'm happy to discuss any issue the court would like to discuss.
I'm interested in talking about the intent aspect of the constructive eviction, the intent prong.
Okay.
So my understanding is that your argument is that intent would have been proven or would have shown up in the evidence that was in the emails in the Exhibit 61 that was denied by the court.
Yes, Justice.
Okay. And so where is the proof of intent in those emails?
So intent in constructive eviction cases, intention is almost always demonstrated by circumstantial evidence. It may be inferred from circumstances. I could cite the court to a lot of cases for that, including the Fidelity versus Mutual versus Kaminsky case. As this court knows, in any case in which intent is relevant, almost always you have to show intent indirectly through circumstantial evidence. Here we actually have direct evidence of a landlord's intention, and that is, here the landlord had a specific choice that was presented to the landlord. Protect your tenant, or conversely, sign away the tenant's rights for the $125,000. And specifically that is to sign away the parking spaces that were used by most of Harvest's customers. The landlord chose, given that choice, the landlord chose to accept $125,000, which the landlord knew and represented to the developer constituted 4 months of rental income that he would lose, plus 4% broker's commission that he claimed he was going to need to find a new tenant.
Well, counsel, as I read Exhibit 61, the 4 months rent and the broker's fee related to the negotiation that was taking place on a potential subsequent lessee and not with respect to Harvest. Am I misreading that?
Your Honor, that was the initial suggestion. One of the emails is we may need to be bringing in a new tenant, either a new tenant or a sublease. But then later on, what Mr. Greenberg said was, by the way, the property was no longer offered for sale, and that he continued to negotiate for 4 months rent. And so that was related. And he specifically said, this is related to based on our existing tenant situation. So yes, Your Honor, it did.
Okay, where does that appear in 61? Do you have a page number?
Yes, sir, I actually do. Let me get that for you. Our existing tenant situation.
If you don't have your fingers on it,
Yeah.
a supplemental letter would do just fine.
I actually can provide it, Your Honor. I'll provide it when I come back up for rebuttal.
Sure.
I do have that at my I do have that available.
All right.
To go back to intention, though, what we do have as a result of this is we have choice plus knowledge. And so the cases, if there are a lot of cases that talk about contention in here, being circumstantial, and when, for example, and this evidence, the choice plus the knowledge, the action plus the knowledge is intention is enough for the jury to infer intent. I would point the court to authorities under the Fidelity case.
I'm sorry, which case?
Fidelity versus Kaminsky, 768 Southwest 2nd, 818, in which this court held that the failure to stop protesters, despite knowledge of its impact on the tenant, was enough to infer intent.
So your position is act plus knowledge equals intent.
It is enough, yes, Your Honor, it is enough for the jury to infer intent from the circumstances. The same is true from Coleman versus Rotana, 778 Southwest 2nd, 867, in which the Dallas court held that the failure to enforce the landlord's contractual rights with other tenants, which then led to insufficient parking for that restaurant, was enough for the jury to infer intent. Briargrove versus Villar from the First Court of Appeals, also reduction of parking places was enough to infer intent. Steinberg versus Medical Equipment, 505 Southwest 2nd, 692, the failure to stop trucks from parking in front of businesses. And then Richker versus Jordandis, which is 323 Southwest 2nd, 90, allowing construction to shut off view of the restaurant and impede customers' access. Those are all cases that are similar, and I think the jury could infer intent from choice, actual act, plus knowledge of what that act would result in for the customer, for the tenant.
If we were to hold that Exhibit 61 should have been admitted, what then is the appropriate remedy?
The appropriate remedy there, Your Honor, is remand for a new trial on
all issues except the one that you won on?
No, Your Honor. So thank you. There's a judgment tree here. So yes, remand for a new trial except on these issues. Number one, there should be a partial rendition on the releasing expenses because there's legally insufficient evidence that those damages were reasonable. And secondly, yes, we won on the fixture, furniture, and equipment. That is, the landlord did not move to disregard that finding, but instead moved for entry of judgment on the entire verdict, and in doing so embraced the entire verdict. And so that would be based upon the law of the case doctrine. Justice Wilson, the court can get to a remand either by the erroneous exclusion of evidence or by the point on repair expenses, which I'm going to touch on briefly. That was teed up as a rendition point. Candidly, the more I look at this, it's not a rendition point. I think it's a remand for new trial because.
So which one would be a remand rather than rendition?
That's the legal insufficiency of evidence on the repair expenses, which I believe is 3D on the jury charge.
And that would be a remand on?
That's a remand for new trial on everything under Rule 44.1. And I can address that very quickly. Again, this was teed up as a rendition because there is indeed legally insufficient evidence that $100,000 was the amount of money that was fair and reasonable to compensate the landlord for damages. But when I looked at it, really what they've teed up here is, and I'm going to get into the weeds in just a second, their claim is, no, we didn't pay the money, but the repairs were made because we gave rental abatement to some of the subsequent tenants. Now, one of the subsequent tenants, Beer Nation, we know the amount of that. That was $50,000. But that
was just for the rental abatement, right? Not for the actual repairs. There are no receipts for repairs. It's in lieu of. It
is in lieu of, yes, Your Honor. And the argument is we had to give them $50,000, which was 2 months of free rent for Beer Nation so they could make repairs. Apparently they didn't make repairs anyway. Whether we're entitled to credit that might be an issue in a retrial, but it's not in front of the court before now. The second tenant is the one that actually makes the repairs, and that's Ebony. It's the restaurant that comes in afterward. The testimony that the landlord presented was we gave them 3 months rent, free rent, and we gave them a year's worth of half rent. The trouble is we have no idea whatsoever what amount of money that is. Unlike Beer Nation, where they actually put the amount of money in, and actually in this record we have Beer Nation's lease, not only do we not know how much money Ebony was paying per month, therefore we don't know how much could have been what 3 months means or what half rent for a year means. So not only do we not have any direct evidence of it, the jury couldn't have figured that out because we don't have the lease in evidence either.
Was that the fault of your client at the trial level? I mean, was that something that your client should have put into evidence as a evidence of a credit?
No, Your Honor, it's not an offset for us. It's actually because it is an element of their damages to prove their damages for repair expenses. And so their damages for repair expenses are we gave some amount of rental concessions for Ebony. So we don't have any evidence about the amount of concessions that were given to Ebony. I would submit, candidly, I think there is some evidence because they said we did give concessions to Ebony, that there's evidence of some amount that was spent on repairs. We just don't know what that is, and so I think
why would that be a remand rather than a rendition?
Because what usually happens then is, I'll find the case here. What usually happens then on the under Guevara versus Ferreira case and other ones like that, if we fall into the rule that says when there's no evidence to support the amount awarded, but there's evidence to support some amount, it goes back for a new trial and remand. It's no longer a rendition point because there's now legally insufficient evidence of some damages, just not in the amount awarded. I see my time's about up. I'll be happy to come back with, Justice Wilson, the question for me was on.
It was where in Exhibit 60, what's the page number in Exhibit 61 that the $125,000 4 months related to existing tenant rather than subsequent tenant?
I will find that for you.
Because Exhibit 61 is a bit lengthy.
It is, Your Honor. Thank you. I will find that for you. Thank you.
May it please the court. I'm going to address a couple of salient points that I think are going to guide the court's analysis to my time before the court. So first off, what has not been mentioned, but what was briefed and is in the record, is that Harvest had some money issues well before the 9/9/15 departure or abandonment. There were instances well before then when Harvest approached 11681 about getting some help. They came up with the gross or not idea to try to revamp, to gather a new market. That happened earlier. And then they approached about getting some relief and trying to find a new tenant and asked 11681, help us find a new tenant to take over. We're not going to be able to make it. 11681 found a new tenant in 2 weeks, which for that size space and that size lease and that length of commitment was pretty quick, and approached appellant about that. Appellant then said, no, we have 3 other locations that are in great areas. We are worried about what that's going to do to our image. We're going to try to keep a go at it. And so that's something that's very important that came into the record, and that is something that I think the court needs to consider when not only considering the admissibility or whether it was error to not admit the BCV records, but also in the other issues. Because what Judge Schaefer saw during this very lengthy argument and discussion about the BC records was the whole case, and that's not what has been brought to the court. There's that issue, and I also want to provide the court the contract specifically allowed. It had a carve out that allowed 11681 to approach and to renegotiate parking. Parking was not guaranteed in the manner and method that it's been implied. And so there is a carve out in the lease agreement between my client and opposing counsel's client that specifically allowed for my client to renegotiate the parking that would be allowed.
But not unilaterally renegotiate.
Not unilaterally, of course. But what has been represented, Your Honor, in the briefing and whatnot, is that somehow that easement for parking for those additional spaces, and Your Honor, you hit the nail on the head, there were 70 that were allotted, but to get the 110 that was required, there was this easement for the common use of those parking spots. And so those common parking spots was shared by a number of different businesses. In addition, the record is not clear, and I think that this is something that should be pointed out, whether or not the parking spots behind the building were in fact guaranteed, because the representation in the briefing is that somehow the parking behind the building was what his clients, or rather Harvest clients, had to use. But it's not clear by either side whether or not those in fact parking spaces were those that were covered in the lease. And I want the court to be aware of that as well. Now, looking at the BCV records, and everyone in this room knows Judge Schaefer, and I've been on the receiving end of a scathing objection, and I've been on the giving end of a scathing objection. He really looked at these BCV records multiple times throughout this trial. He looked at it from the beginning when an objection was made on the relevance, and he sustained it. And then after the offer, a lengthy offer of proof was made, there was a substantial argument again. It's at volume 8 of the record, pages 140 to 149. And you'll see the evaluation and the arguments that Judge Schaefer considered. And what he's...
Well, let me ask you this. If indeed the 4 months rent plus the broker's fee, as Mr. Morrow argues, and he'll give you the page number, if indeed that relates to the existing tenant as opposed to a subsequent tenant, doesn't that then prove up the second element of constructive eviction, that is a material act that substantially interferes with the tenant's intended use?
Respectfully, Your Honor, I don't think so, because there were other spaces of that common use that were afforded. It isn't like if there are 70 that are guaranteed and there are 40 that are common use amongst all of the tenants in that strip center, it is not like all the other parking spaces were then taken up by the encroachment from the construction.
Yeah, but what he's saying, what the landlord is saying, what Mr. Greenberg is saying is, look, I'm going to lose rent because of this encroachment and the lack of parking spaces. That's an admission by him, and isn't that an admission that allowing this renegotiation of this of the parking space agreement, isn't that an admission that that act, that renegotiation, interferes with the tenant's intended use?
Your Honor, I don't think so. I think that when you look at the record and you look at the reasoning that the trial court made, the trial court recognized, he specifically says, I see a discussion, but I don't see anything that constitutes selling out your client in any of this. You know, I see a discussion of Mr. Greenberg negotiating with someone to get some benefit for giving up something that he has a contractual right to. And Your Honor, that is what it is. There is no reference to Harvest. And at that time, there was, to 11681's knowledge, that there was no problem with Trader Joe's carving out some additional space other than what it was already entitled to move in and to be able to build out. There was no written notice of any issue with that. Had there been a discussion? Maybe. There's a disputed fact in this record of whether or not there had been a substantive discussion about the fears and concerns of Trader Joe's moving in. But what was in the record is Judge Schaefer looking at the entirety of Exhibit 61, and not a framing of it, but he looked at the entirety of the
Didn't Mr. Greenberg on several occasions open the door to this by saying, "Oh yes, I talked to Trader Joe's or to Kohl's, and we talked about sewer lines and the like, but we didn't talk about parking at all." Why didn't that open the door?
Open the door to the entirety of Exhibit 61, or just any evidence in Exhibit 61 that related to sewers or related to sewer lines?
Or specifically to parking, if he's saying that they did not talk about parking and Exhibit 61.
Clearly he did.
Right.
So, Your Honor, I think that when you look at whether or not, I think where you're going, and I'm not trying to put words in your mouth, is could it have been used for impeachment? Could it have been used to say, you've gone on the stand and you said A, B, and C, these records show C, D, and E that directly contradict what you've testified? I believe that's where you're going. And when you look at the impeachment, it's not as clear, and I think that's where Judge Schaefer found it. You don't see an A for an A and a B for a B. You see, amongst the very lengthy exhibit that y'all have recognized, you see a lot of discussion negotiating the use of the easement. You see a lot of discussion, and it was a negotiating ploy. You can see that there was a little bit of bluffing and poker going on. Mr. Greenberg talks some big talk about how much it was going to cost. Initially, Trader Joe's, I believe, offered $25,000. He's like, that's never going to be enough.
He said that's 1 month.
What?
And this is going to be a 4-month disruption.
It is unclear it was going to be a 4-month disruption, and if you look at all the fees, including the CAM fees, $25,000 was not the total base rent that was being paid by Harvest. I believe it was almost $31,000. And so it isn't an eye for an eye on this, Your Honor. Do I think that it was puffing? Do I think that it was a negotiating ploy? Yes, and that's exactly what Judge Schaefer saw as well. And so, Your Honor, when we look at the BCV records, we also have to look at whether or not it meets those elements for constructive eviction. And when we look to those 4 elements for constructive eviction, I want to also point out to the court that the appellant has made no argument whatsoever challenging the jury's finding of no evidence on this. And so the entirety of their constructive eviction argument is on these records. And I understand that that's the argument they're making, but that doesn't make this evidence crucial. And when you look to the JBS decision and we look to what the prongs and the tests are that this court has to evaluate to whether or not the exclusion of this evidence was harmful, we see that they have not met that vote. We look at 3 specific factors under JBS, and we look at those factors. We see whether the evidence was cumulative. Well, Your Honor, there was ample testimony in the record already that went to the appellant's constructive eviction claim. The corporate representative got up and and constructive eviction was discussed ad nauseum during the trial. There was actually an objection about constructive eviction not getting 2 questions in the jury charge in this trial. But in addition to it being cumulative, even if you take the framing that the appellant is offering, you then have to look at whether or not it was one-sided. Judge Schaefer even acknowledged there is some stuff in Exhibit 61 that actually hurt the defendant appellant in this case.
Yeah, what is that?
I would love to be able to...
Because I couldn't figure that out. I know what you're talking about, the statement that Judge Schaefer made, and I cannot conceive of how it would be harmful to the appellant. So I was curious if you had an idea about how that would be.
I don't know if Judge Schaefer's watching this oral argument, but what I will say is...
Hi, Judge Schaefer.
Hi, Judge Schaefer. What I will say is, I think what it could potentially hurt is more of the jury getting very confused on what was going on. And what you had, absent the BCV records, is a company that was struggling for a while to be able to make ends meet, that it tried to reinvent itself in the, what is that, grocer-not, I'm going to use the word, across from the Four Seasons. That's a grocer-not. It's got a grocery, and then it's got a little restaurant where you can go and get food. It was trying to reinvent itself because it was struggling. And then you have the March 15th where it was struggling. And so you've got evidence in the record that is undisputed from the appellant's corporate representative that shows that there is a real struggle with constructive eviction, their constructive eviction claim. And
Well, I appreciate your argument that Judge Schaefer looked at all this and looked at the totality and was well versed in this, but he also said, if I'm wrong, this is reversible.
He did. He did. And Judge Wilson, I remember when you were on the trial court bench, and I'm certain, because I do know Judge Schaefer, and I remember being before you, when you make rulings, these aren't rulings that are made off the cuff. These aren't knee-jerk type of rulings. And when you look at the record, at the lengthy
It doesn't
argument,
mean he can't be wrong.
It doesn't mean he can't be wrong. No, of course. But all I'm saying, Your Honor, is I think that when Judge Schaefer made that comment, which was in the cited provision I just gave you, the 144 to 149, This, I think, was like the 4th or 5th time that the issue had been raised. It had become hotly contested. Do I think that Judge Schaefer made that comment because he realizes this is a bigger issue than just relevance? I think that's what spurred that comment, Your Honor. Not necessarily, oh, I've made a mistake, the whole thing is going to get thrown out, maybe with the bathwater.
No, that wasn't the purpose. He wasn't acknowledging an error. He was just saying, if I'm wrong, hey, this is reversible.
Which any evidence that is wrongfully excluded would be reversible, right? I mean, if it in fact is wrongfully excluded, which as we've briefed and argued in our 12 minutes so far, it was not, then it would warrant a reversal and a remand. And I think that that's just Judge Schaefer being aware of this court across the street and not necessarily anything else. In their time before the court, appellant...
Well, can you address one of the last issues that I talked about with appellant, and that is the Ebony, the damages with respect to Ebony, and it was never quantified, and therefore there is no evidence of the amount. But appellant's argument is that because there is evidence of the existence of injury but not the amount, it's a remand as opposed to a rendition, and if it's a remand, it's a remand of everything.
There's actually 3 issues on what you just said, Justice Wilson. So I've got 2 minutes and 45 seconds. I'm going to try
Give
to
it a
get
shot.
all of them. I'm going to try. So let's talk about the first thing, which has to do with the evidence of the damages. So the plaintiff's exhibit 4, which is our damage model, which is in the record at volume 9, page 41. It's a very detailed damage model that shows all of the numbers. And in it, you'll see not only is there the credit for the $1,000 security deposit, which is hotly contested, but you'll see that there is evidence of the damages that were incurred. And then when you look at the contract, nothing within the contract, and it's paragraphs 14.21 and 14.24, and I briefed it, Your Honor, at beginning at page 28 of my brief, I believe. Nothing within the lease requires the expenses to be paid. They need only be incurred. And when you look through the evidence of what was submitted, and specifically the record, volume 7, pages 186, line 6 to 191, line 24, you'll see some lengthy testimony where he talks about the expert Siblick and his testimony about the damages that were incurred to repair and return the building to the condition that it was in when it was leased to Harvest. And so from 32, his name was Sibic, he testified regarding a number of different amounts, of which a running injection was maintained. And so, like for one example, how much would it cost to do the demolition? The demolition was going to cost $35,250. How much would it cost to fix the interior framing and finishes to bring it back to where it was when it was when it was initially leased? $41,996. What about
with respect to Ebony? The argument was, as I understand it, that we gave rent concessions to Ebony to take care of these repair and remodeling expenses, but those concessions were not quantified.
That is the correct statement, Your Honor. But at the end of the day, there is evidence in the record of the costs that 11681 had to make up by giving those rental concessions. So I think the focus that appellant is trying to make is that we should be focusing on how much Ebony benefited by having to take on the cost of fixing the repair. And that's not the damage model. The damage model is the evidence in the record of Civic coming in, looking at the status of the state rather, of the building when they were vacated.
So your position is if there is evidence that it would have cost, let's say hypothetically $100,000, but in fact they gave rent concessions, and even though we don't know how much those rent concessions were, the $100,000 is the correct number?
Well, Your Honor, not exactly. What I'm saying is there's evidence in the record that to return the premises to the condition that it was in, it was $342,541.23. That is what it would have cost to repair it and return it to that original condition, which is what the appellant was obligated to do. What I'm saying is we aren't required to put in evidence of the concession made to Ebony because we've got evidence in the record of what had to have been done to return it to that condition.
So even if they only gave rent concessions of $100,000, you're entitled to the full $300,000.
What I'm saying is we don't know that the rent concessions weren't $342,000. There is a gap in the evidence of the record of that. I will acknowledge that, Your Honor. But what I'm saying is there is no gap of what it would have cost to return the premises to that condition. And that's the $342,000.
Okay.
I see that I'm out of time. Thank you, Your Honor. Your Honors.
At the top of my outline, I always put talk slowly, and I highlight it, but I've got 3 minutes.
Don't talk slowly.
I'm not going to
Talk
do it.
fast.
I know it's going to be recorded. Okay, Justice Wilson, to your question, I want to provide you both a Bates number and the record reference. As to when they talk about it being based on current tenant situation. The record number is volume 12, page 98, that's corresponding to PDF. The Bates number is page 25. It's an email from April 2nd, 2015. Email from Mr. Greenberg to Brian. If we were to consider some form of value based on our existing tenant situation, their monthly obligation is $30,932 per month. 4 times that is $123 plus change, plus the real estate commission of 4% equals 60%. And then at the end of that email it says, FYI, the property was taken off the market for sale. Clearly here, we're now talking about our current situation. And that's also then clear on Bates number page 29. This is actually an email back from Mr. Vaughn to Mr. Greenberg, where they offered $100,000 to you or your tenant. I continue to hear what seem to be jury arguments about subleases and my client struggling. The only evidence in the record, these arguments about struggling, they are lawyer concoctions. They're arguments, and lawyers are allowed to argue about that. The evidence in the record is that we made a small profit, we never lost money, and we always paid our bills through September of 2015. That comes from volume 5, pages 21 and 22, and volume 6, page 22. I know we're no longer in baseball season, we're a few months away. I like Justice Schaefer, but nobody bats 1,000. And so the fact that he spent a lot of time looking at this and that he made the decision he does doesn't change the fact that it was erroneous and that it was harmful, as he acknowledged.
How do you respond to Ms. Hadaway-Cohen's argument that the lease agreement allowed the landlord to make to make this agreement vis-a-vis parking? Doesn't that go to both element 1 and 2 of constructive eviction?
The argument of contractual entitlement goes to, no, Your Honor, I'm struggling a little bit. There's one case that talks about this, so trying to answer your question directly, I don't know which element it goes to. What they say in 1221 Eldridge Road is that it goes to whether there was a substantial interruption. And let me suggest 1221 Eldridge Road is a fine case. It is not the King's X they think, because it is a loosely written memorandum of opinion. In that case, what we're talking about was a $3,200 amount that the tenant was required to pay. Not surprisingly, the court held that just because we're making you pay $3,200, that's not substantially interfering with your use and enjoyment of the property. Our record is different. Since I'm almost out of time.
I actually have a question before. So
Yes.
Finish up and I will ask you.
I'm just going to present my prayer, Your Honor.
Oh, okay, well then. So you state that page 2280 of the clerk's record contains proof that the trial court's denial of the post-trial motion to disregard the jury's answer, that's proof of the trial court's denial of the post-trial motion to disregard jury's answers.
Yes, Your Honor.
Okay.
I would say that, and I don't have perfect recollection of that.
I
If that
understand.
one- if not-
It's a reference to the docket sheet, not to the actual order.
There may not be an order in this record, Your Honor, because for all I know, it may have been that it was overruled by operation of law. I don't have that answer in front of me. I'm sorry.
I think it was by operation of law,
Okay.
as I
Okay,
recall.
and if that's the case, that would explain why we don't have a written order on that.
Okay.
Um,
That was my only
So
question.
before you get down, one final question. Back to the ebony damages, how do you respond to Appley's argument that it doesn't matter what the amount of rent concessions were, there's evidence of what it would have cost to restore the property to its original condition?
I would agree with her if that were the end of the question, asking what's reasonable and necessary. The question, actually, question 3 asks for more. What are their damages? What would fairly and reasonably compensate them? Compensation for damages. Let me submit that if I get into a car wreck and my Jeep is damaged, and I can trot up a mechanic who says that it's $20,000 to repair it, but then the actual evidence is,
Give me the question. Give me the actual jury question again.
it is question number 3. I've got that right here. I'll read it to the court.
Because I see where you're going. I just want to hear the actual question.
What sum of money, if any, if paid now in cash, would fairly and reasonably compensate landlord for its damages, if any, that resulted from such failure to comply? We have compensation, we have damages, and we have a causation hearing. Going back to my stupid analogy, if I get up there and say, I've got a mechanic who says it was $20,000 to repair my Jeep, but I actually present evidence that I gave my neighbor $50 and a case of beer to fix it, what are my damages? I might have presented evidence about what's fair and reasonable and necessary, $20,000. Those are not my damages. That's not compensation, and that wasn't caused by the failure to comply. If there are no further questions, appellants, Pure Investment Group and Eunice Dogan request that the court render judgment for them in part, remand for a new trial on other issues. Alternatively, we would ask that the court modify the judgment by applying our security deposit by ordering a redetermination of judgment interest and by remanding for a new trial on attorney's fees. Thank you so much.
Thank you.
Thank you.
Thank you, counsel. The case is submitted and we are adjourned.